Or you want to be in the
Oh, I
middle?
can go in the middle.
Yeah, that's great.
The wedding, should we just cross over?
Yeah.
Okay.
Yeah, that works. That way I can see everyone.
This is on the bride or the groom side. So we saw.
All right. I'll just give a quick introduction. I think I'm gonna put myself here for the benefit of those watching online, but I promise that I'll be very short. And hi, everyone. I'm Rafael Carmona, director here at the ICDR. And just before we commence this one, to first thank you all very much for coming. Thank you to also the remote attendees and to our panelists. Just as a reminder, this is an event as part of our Young Practitioners Group, ICDR Young and International. If you want to join the group and see all the events, webinars, and programs that we organize, if you go to our website, ICDR Young and International, you'll find registration forms there in English and in Spanish, as well as a library of supporting webinar programs. Also, we have a LinkedIn group. Again, the name is ICDR Young and International, and you can request to join, and we'll be posting all of our updates there too. With that, again, I don't want to take more of your time. You haven't come here to hear me talk, but to hear this excellent panel. And I'll give the floor then to Katie Gonzalez, who will be the moderator for today. Thank you all.
Great. Thank you, Rafa, and thank you to the AAA ICDR and the ICDR Y&I for being our hosts today. So my name is Katie Gonzalez, and I'm a senior associate at Cleary Gottlieb Steen & Hamilton here in New York, and I'm going to be moderating this panel, the topic for which is Functus or Flexible, Tribunals, Authority, and Powers at the Edge. And we have really a great roster of panelists who are going to be speaking on this topic today, who are not only sort of geographically diverse from different parts of North America, but also I think present a very interesting and broad perspective. So we'll be hearing from outside counsel, in-house arbitrators, and members of institutions and people who work at institutions themselves. So with that sort of introduction, I'll just take a brief moment to provide a short bio for each of our panelists. First, we have Frida Altamirano, who's the Secretary General of the Arbitration Center of Mexico, or CAM, which is a private arbitral institution established in Mexico City since 1997. Prior to joining CAM, Frida was a member of the Mexican Foreign Service and worked in Canada and the United States. We also have Liz Robertson, who's in-house counsel for the American Arbitration Association International Center for Dispute Resolution, or AAA ICDR. And prior to joining the AAA ICDR, Liz served as the director for the ICDR, where she managed international arbitration and mediation cases and participated in various development and outreach efforts for the ICDR and ICDR Canada. We also have Kateryna Shokalo, who's an associate at Ellsberg, Baker, and Maruri, a trial boutique in New York. And she advises clients on complex commercial disputes in litigation and arbitration. She is qualified in 3 jurisdictions: New York, England, and Wales, and Ukraine. We also have Mark Stadnyk. Mark is the senior legal counsel for North America based in Houston for Tyson Krupp Nucera, a leading electrolyzer manufacturer active in the production of hydrogen on an industrial scale. And previously, Mark acted as, for over a decade, as international arbitration counsel at firms in Paris, New York, and Houston, representing publicly traded companies, sovereign states, and state-owned energy companies throughout the world, including before all major international arbitration institutions. And finally, we have Grant Hanessian, who's an independent arbitrator based here in New York, specializing in international and complex commercial disputes. And prior to July of 2020, Grant was a partner at Baker McKinsey, where he practiced for 33 years and served as the global co-head of the firm's International Arbitration Practice Group and head of its New York litigation department. He's also an editor at the ICDR Awards, of the ICDR Awards and Commentaries, Volumes 1 and 2. So with that introduction to our panelists, I want to sort of provide an introduction to our topic, which is really going to be about the scope and the limitations of arbitrators' authority. And in order to try to do this topic justice in just an hour, which we have here today, I think it's important to probably remind everyone of the maxim that arbitration is really a creature of consent. And so arbitrators are typically appointed by the parties on an ad hoc basis. And at least when I think about where a tribunal might derive its authority from, my sort of immediate instinct is to go to, I think, where we often begin our cases, and that's the arbitration agreement in the parties' contract. But I'm wondering, and maybe Kate, I can ask you to kick us off, if this is sort of the beginning and the end to where we find authority for tribunals' jurisdiction, or are there going to be other sources where tribunals can draw their power from?
Thank you, Katie. And I agree with you and with your instinct. But in addition to the parties' agreement, tribunals, depending on the context and jurisdiction, might derive their powers from such sources as inherent powers as recognized by common law or arbitral statutes, or if you agree with Emmanuel Guillard, transnational legal order, arbitral legal order. But coming back to the arbitration agreement, I would like to highlight that typically when we think about arbitration agreement, we think about agreement to delegate the merits disputes to arbitration. I'll call it master arbitration agreement today. But in addition to that master arbitration agreement, parties typically agree or can agree to delegate additional threshold jurisdictional issues to the tribunal, such as jurisdiction to decide its own jurisdiction, jurisdiction to award costs, even if the arbitration agreement on the merits is absent or invalid, jurisdiction jurisdiction of the expedited arbitrator, or jurisdiction to revisit, correct, and interpret arbitral awards, the final arbitral awards. And the parties' agreement as to each of these narrow issues, in my view, can be treated as a separate arbitration agreement on that specific issue. I'll call it a parachute arbitration agreement today, and later on, I'll show you why this parachute arbitration agreement actually matters and why it can make or break enforcement of an arbitral award.
Great. And so Kate, you mentioned something which I think is, sort of really important to discuss at the outset, any, topic of conversation surrounding tribunal's jurisdiction, which is, of course, the tribunal's jurisdiction to decide its own jurisdiction, which, oftentimes we refer to as competens. And I'm wondering, Grant, if you can sort of provide us with an overview of this concept and how you see it arising in conversations relating to tribunal's jurisdictions.
Okay. Thanks, Katie. Thanks to the ICDR for asking me to come. Full-time arbitrator for 5 years now, probably 60 cases or so. I don't think I've ever heard competence discussed by a tribunal in those terms. And in thinking about what I was asked to talk about, competence is not in the Federal Arbitration Act. It's not in 75, the CPLR. So why do we talk about it? So when I do talk about this, which is at Fordham Law School where I teach arbitration, we talk first about separability. So what is that? I'm looking forward to shoot arbitration contract. That's a new term for me. Separability, as we know, is this idea that the arbitration agreement is separate from the rest of the contract, which is sometimes called the container agreement, parachuting containers. And the concept of an arbitration agreement is in the Federal Arbitration Act. That's in Section 4. It actually talks about and of course, the Federal Arbitration Act is 100 years old, right? This is a centenary of the Federal Arbitration Act. Lots of these things are much more clearly laid out in more contemporary national arbitration law, like the instrumental law. Section 4 says, if the making of the arbitration agreement, failure, neglect, or refusal to perform the same be an issue, or it shall proceed summarily to the trial thereof. So it's the making of the arbitration agreement, not the itself. So in Prima Paint, 1965 decision, Supreme Court, the court was seizes on that concept of an arbitration agreement. Says, okay, that's for the court. Everything else must be for the arbitrators. And so this is the separability, but this is also the competence. And the arbitrators must be the masters of the rest of this, of their arbitration over the rest of this. So, you know, there is a kind of, it's a bit of a rabbit hole, but there is a way to find the origins of this in our law. We leave it there for now, and then we'll come back.
Absolutely.
Come back to it.
And it's interesting, I think, you know, we will probably come back to sort of the tension that exists between courts and arbitrators when you talk about jurisdiction. And, you know, I appreciate that we're sort of focusing so far on, you know, the arbitration agreements. But I'm wondering if we can perhaps pivot to some of the institutional rules and talk about, you know, how the institutions are addressing issues like tribunals, jurisdiction, or competence. And perhaps, Liz, we could turn it to you for sort of the perspective from the institutions and how, if at all, they're addressing this.
Sure. So it's very important, I think, to have competence as, you know, one of the main foundational or bedrock principles to an efficient arbitration process. Makes it very important for that to be addressed in the institutional rules. So this being an ICDR event, I'll start with the example of the ICDR International Dispute Resolution Procedures. This current most recent set of rules that was updated in March of 2021, and Article 21 of the rules is titled arbitral jurisdiction. So it really spells it out here, starting with subsection 1. It says the arbitral tribunal shall have the power to rule on its own jurisdiction, including any objections with respect to arbitrability, to the existence, scope, or validity of the arbitration agreement or agreements, plural, or with respect to whether all of the claims, counterclaims, and set-offs made in the arbitration may be determined in a single arbitration without any need to refer such matters to a court. Subsection 2 of the same article adds some more color and goes a little bit into separability. It says the tribunal shall have the power to determine the existence or validity of a contract of which an arbitration clause forms a part. Such an arbitration clause shall be treated as an agreement independent of the other terms of the contract, and a decision by the tribunal that the contract is null and void shall not for that reason alone render invalid the arbitration clause. So there's two more subsections after that. Sub 3 goes a little bit more into timing, but also gives the tribunal flexibility in that regard. So it states that the party must object to the jurisdiction of the tribunal or to arbitral jurisdiction respecting admissibility of claims no later than the filing of the answer to the claim that gives rise to the objection, and the tribunal may extend such time limit and may rule on that objection as a preliminary matter or as a part of the final award. So there's some flexibility there. And then the final subsection, I'll give a little more color to in a later question, but it states issues regarding arbitral jurisdiction raised prior to the constitution of the tribunal shall not preclude the administrator from proceeding with administration and shall be referred to the tribunal once constituted for determination. So depending when the subjection comes up, that provides some really good guidance in terms of efficiency. Similar provisions to these appear not only within the ICDR international rules, but across the other AAA rule sets, which likewise address, you know, this idea of competence. That's Rule R7 of both the commercial rules, the consumer rules, as well as the employment rules, R9 within the construction industry rules, and then Rule 3 of the labor rules. I'll address that and make it very clear. The arbitrator shall have the power to rule on their own jurisdiction, and this is a question for the arbitrator to decide.
So it definitely seems like this is, you know, an important enough concept and sort of construct, you know, in empowering tribunals to act, that institutions are incorporating it into their rules and sort of enshrining it, you know, with some of this mandatory language list that you mentioned. So I'm wondering, you know, to try to perhaps give us an even more broad or global perspective, Perhaps we've been focused on, the United States and international and arbitration institutions, but Frida, can you sort of provide us with, some insights in terms of, is the application of competence, similar across all jurisdictions, or are you seeing, sort of unique parameters of it in Mexico or other places?
Actually, Mexico's a civil law country, so we follow the French tradition and we focus on the negative effect of competence. So this one is recognized by law. It's in the commercial code on the fourth chapter of the fifth book of the commercial code. So it is Article 1432, which recognizes the power of the tribunal to rule on its own jurisdiction. But there has been some criticism in regards that it is the judge who has the final word, because if the tribunal rule on its own jurisdiction, the party against that decision might go to court and ask the judge to rule on the decision. So you can have, or you can end up with parallel proceedings. And Mexico, even if we are a model law country, we don't adopt the amendments of 2006. So most of the development of the competence principle has been developed by jurisprudence. So we had a lot of reforms from 2011, that we are part of NAFTA, TEMEC now. So most of these reforms are product of treaties, international treaties, and some requests from other jurisdictions to make Mexico a better seat for arbitration, or at least to attract more investments. So after 2011, we have found a bit of reforms. So we cannot say that competence, even if it's in the law, it's only interpreted by the courts based on the law. It has to bring more jurisprudence and more criteria. You probably know that we're going through judiciary reform now. The election was last Sunday. So we are not sure if the new judges will follow the same jurisprudence and the same developments that we have been following in the last years. So Grant was mentioning that maybe here in the US, the arbitral tribunal are the masters of the arbitration agreement, but I would agree, and probably the same wouldn't happen in Mexico.
Okay. All right, so yeah, I'm going to follow that a bit with and trying to be clear about some of this. So when we talk about competence, we talk about the competence of the arbitrators. When we talk about negative competence, we talk about what courts shouldn't do. Right? The negative competence goes to the courts. So, sorry.
Separate a little bit the mic. I think that's the main goal.
Okay. All right. Sorry. In the United States, we don't really talk about negative competence, but there is this concept. We do see this with respect to certain kinds of jurisdictional issues. And the way that this has developed over time in our Supreme Court cases is that substantive, well, let me say something else. The definitions here are very tricky because different courts in different countries use the same words different ways. Arbitrability outside the United States is limited to the power of an arbitration tribunal to decide a certain subject matter. Until Mitsubishi, U.S. arbitrators couldn't determine antitrust competition matters, that sort of thing. There are very few business matters that are not subject to arbitration in the United States, but that's not true around the world. Intellectual property, patent issues and such can't be arbitrated in certain jurisdictions. Most of the world considers that what arbitrability means. In the United States, arbitrability means much more than that. And it's not just the existence, validity, and scope of the agreement, but there are also procedural admissibility, things like limitations, waiver, condition precedents, if there's a mediation clause, that sort of thing, and estoppel. These are all different kinds of jurisdiction or gateway, as George Berman likes to say, so-called gateway issues. And the way that our jurisprudence is developed in the United States, the first group of these, substantive arbitrability, existence, validity, scope, these are things that if if you go to court in the first instance with an arbitration agreement, you're entitled to have a court rule on these things. Notwithstanding the competence of the arbitration tribunal to decide them if the party opposing them doesn't go to court. This is first options case. The negative competence in the United States is that if the party opposing jurisdiction goes to the court in the first instance on its procedural admissibility issues, the court is not supposed to determine under our law. So there is, people say there's no negative competence in the United States, but there is a negative competence with respect to so-called procedural admissibility issues. This is the Howsam case. So-
No, pero puedes poner el Snapchat.
So I think that's really interesting, and both Grant, you and Frida mentioned sort of
Nada
the,
más
you
que
know,
no le vas a
intersection
poner micrófono.
courts and arbitrators and sort of this question of who decides. And at least from my perspective as counsel, oftentimes, you know, we think as the arbitration agreement, a place where we can perhaps try to rein that process in and make it absolutely clear who's going to decide that question, you know, provided it doesn't run afoul of any, you know, laws. But Liz, I'm wondering if you could maybe, you know, add a little bit more context there and talk about, are there ways that parties can think about drafting their arbitration agreement to perhaps, you know, provide some direction in terms of what the arbitrator's jurisdiction will encompass?
Sure. So I think I'll start by saying the best way to avoid such questions when drafting would be to incorporate a set of institutional rules into your clause, like we discussed before, where the tribunal's jurisdiction and competence are specifically addressed and laid out within the rule set that's going to govern your arbitration. So as a very explicit drafting tip, you can go right there to the ICDR rules in the introductory portion before the actual articles begin. There is a set of drafting considerations. So there's a model or template clause that parties can insert into their contracts. It's a basic standalone clause providing for arbitration of all disputes administered by the ICDR in accordance with the international arbitration rules. There it goes on to say, you know, a couple additional considerations. Parties should consider adding the number of arbitrators, should be 1 or 3, place of arbitration, language, and so forth. So this is very basic form language that can be used and adapted to fit parties' particular needs. Available at icdr.org, you'll also find a more in-depth guide to drafting international clauses. And that guide includes not just that type of standalone clause, but it has examples of model step clauses, mediation arbitration clauses, concurrent arbitration mediation clauses, party appointed arbitrator clauses, all sorts of things. But in addition to that, what I really want to kind of point everybody to here is a couple more drafting tools that we have available online. They're free of charge, and these are the AAA clause builder tools. And we have a couple versions of these right now. It's an informational and educational tool, but it's developed to assist individuals and businesses with a really fast and easy way to develop really clear and effective arbitration and mediation clauses. So if you go to clausebuilder.org, that's the first original version of the tool. It's very simple. You'll enter your email and see 3 steps. Step 1, select the nature of the type of contract that you're drafting. So you can choose from commercial, construction, employment, international, healthcare, all those different areas. You can select the type of clause, whether you want just an arbitration clause, mediation and then arbitration, or concurrent mediation with arbitration. And then this is new and pretty cool. You can select whether an artificial intelligence dispute may arise out of or relate to the contract that you're working with. So when you select yes to that option, it gives some nice additional language there that kind of, you know, outlines that not only any claim arising out of this contract, but also any claim arising out of the licensing, sale, use of artificial intelligence, large language models, etc. So that's a new improvement. But even cooler than that, I'll plug just really quickly, we've infused Clause Builder with AI technology. This is a beta version, which means it's, work in progress. It's, getting better with time as we test it, but you can be in open dialogue, like talking to a chat bot, tell the Clause Builder AI, all your particular needs, go back and forth as it kind of further refines your clause as you talk to it. So that's kind of a really cool tool that's free, it's out there. So encourage you all to go test it out.
That's great. One thing I would just add in terms of drafting of arbitration provisions, and something I think we oftentimes see as arbitration counsel working closely with our corporate colleagues, is there can be this sort of, desire to, say there's a dispute that's going to go to court and here's a dispute for arbitration, in an attempt to kind of, capture both, forum for resolving disputes. But I think that can oftentimes lead to, ancillary questions in terms of, what is the scope of what can be arbitrated versus what is set for a court. So, sometimes to try to mitigate or reduce the issues that we can see with, questions of tribunal's jurisdiction can be to include a very broadly worded arbitration provision that sort of has all disputes arising under a contract going to arbitration. But perhaps before we sort of progress to, some jurisdictional questions that might arise during the pendency of an arbitration proceeding, I want to first, have a note about emergency or expedited proceedings, because I think questions about a tribunal's jurisdiction might present differently in these types of cases where, time is of the essence and the parties are moving quickly in trying to resolve something, perhaps even just on an interim basis before they even appoint their typically standing tribunal. So Mark, could you please provide us with the in-house perspective on, when you see these questions of jurisdiction arise in emergency or expedited cases, and what sort of jurisdictional issues are implicated?
Right, and I think now we have more tools on the arbitration side to deal with emergency and expedited provisions. That wasn't the case 5-6 years ago. So there is still a tendency, you see it a lot in already signed contracts, but even in the drafting and negotiation phase these days, to include clauses where you say, okay, we agreed to arbitration, but we also agreed to the non-exclusive jurisdiction of courts in such and such jurisdiction for urgent interim relief, whatever. But it does create those issues that you talked about where, what is the line in between the two jurisdictions? What is truly interim, urgent, whatever, and what could go to arbitration or should go to arbitration? So those types of clauses create a lot of issues. They're trying to resolve something else, but they create problems, I think, on the jurisdictional side. So, the answer there from an in-house drafting perspective, I think, is there are a lot of expedited and emergency provisions now that function very well. And to try to rely on those where you can, in lieu of have your cake and eat it too clause where you'd refer to courts for urgent interim relief. Now, I think the caveat with that, or the footnote on that, is that the consideration of jurisdictional issues in an emergency arbitration especially, but also in expedited provisions or proceedings, is oftentimes not great from a counsel perspective, in-house and external. At least in my experience with those two hats on. I did a lot of work representing sovereign states in a previous life and state-owned entities. And especially in an emergency proceeding, it is very difficult for them to activate counsel, get briefed and all that sort of stuff. And they are in a really difficult position arguing not just jurisdiction, but the merits of those cases, and even retaining counsel, honestly, for an emergency proceeding. So I worry that the emergency proceedings are not well suited to address those topics. Also, when you bring in not just sovereign or state-owned entities, but third parties that may be related to the performance of a contract, but there's a legitimate question of whether or not they're included in the scope of the arbitration clause, affiliates, and so on. The treatment of those issues, especially in emergency, but also in expedited, has not been perfect. But again, I'm not sure if there's a better solution out there given the challenges that we talked about with including a court clause.
Absolutely. Well, we'll be interested perhaps to hear from our audience later in case anyone has some other solutions to offer this group for big problems like that and big issues. But perhaps we can, focus our attentions on some of these normal course, the non-expedited or non-emergency arbitration proceedings, and talk a little bit how jurisdictional issues and questions of a tribunal's authority or its power present sort of in that normal course. And Liz, perhaps you could, just provide a very brief, overview in terms of when do parties typically raise jurisdictional issues in an arbitration proceeding, and sort of how is that an issue that gets put before, the tribunal or someone else?
So I'll just go chronologically through the life of the case. But when it happens, when a case is first filed, so in other words, the case has been filed or commenced with the institution, but an arbitrator has not yet been appointed. What happens during that gray area period, when one or more parties are already lodging their jurisdictional objections right from the outset? And as you can imagine, that comes in straight to the institution often. People are objecting very strenuously, and oftentimes will be asking the institution itself to cease administration, stop the arbitration, and not proceed with appointment of the tribunal. So there can be tension there and room for delay if it's not addressed in an efficient manner. So under the AAA ICDR rules, I think the first step in kind of breaking that down procedurally is to make it clear to the parties in that situation that the neutral administrator is not authorized to make legal determinations as to arbitrability and jurisdiction. These must be made by the tribunal once appointed in accordance with the rules. So that's kind of the first caveat. In most cases at this stage, parties are raising legal arguments about jurisdiction, which fall outside of the administrator's authority to decide. So in such instances, the administration continues and the jurisdictional issue is deferred to the tribunal in accordance with the rules. However, the AAA and the ICDR do review administrative jurisdiction by reviewing whether the filing party in the arbitration has fulfilled the filing requirements under the rules. So this is defined, for example, under Article 2 of the ICDR rules, which states the filing requirements as the filing party must provide a notice or a demand for arbitration that includes the name and full contact details for all of the parties. They must provide a copy of the entire arbitration clause or agreement that's being invoked, a description of the claim and facts supporting it, the relief or remedy sought, and the appropriate filing fee. So when the objection comes in prior to the constitution of the tribunal, the administration does review administrative jurisdiction in terms of the filing requirements. So that's another kind of important distinction to make, when dealing with this procedurally. There is a dedicated review council in place of supervisors and executives that review these types of administrative decisions within the AAA on a regular basis. So there is that added level of review and expertise in place to, protect the process and give the parties a quick decision on these type of issues so as not to delay the proceedings further. And then as far as once the tribunal is constituted, if the tribunal determines that it does not have jurisdiction over the entire dispute, administratively, the case would be closed based on that determination. If the tribunal determines that they does not have jurisdiction over only some of the claims or parties, but does have jurisdiction over other claims, then the case would proceed only with the claims or parties over which the tribunal has found jurisdiction. We'll touch a little bit on court intervention, I think, in a second, but if a party does go to court and successfully obtains a court order directing the manner and how the underlying arbitration should or should not go forward, the administration will, of course, abide by that court order. So, yeah.
Absolutely. And I think when we talk about sort of objections to a tribunal's jurisdiction, probably very top of mind for many of the people in this room and on our Zoom is this question of whether you can or perhaps should bifurcate so you can resolve issues of jurisdiction early on in the case before getting to other stages, pertaining to liability or quantum. And this is perhaps, a more familiar concept in investment treaty cases, but I'm wondering, Frida, if you can kind of speak to your experience in the commercial arbitration realm. Is bifurcation of jurisdictional issues something that you're seeing? And what might be the pros or cons of bifurcating this jurisdictional question?
Regarding bifurcation, what I have seen is that the tribunal or the arbitral tribunal is willing to do it when you have multi-parties. For instance, we have cases regarding insurance and reinsurance. So we had, for instance, insurer and then 3 other parties. So of course, the arbitral tribunal made a decision to bifurcate the case because they had to decide whether or not one of the reinsurers were part of the arbitration agreement. And then in the end, they decided that one of the parties was not a part of the arbitration agreement because he didn't sign and he didn't act on behalf of one of the insurers. It's only part of the transaction. He was only part of the transaction, but he never agreed to the arbitration agreement. So they render a partial award on that. And the second one that I have seen is when it comes to the applicable law. There was a discussion on a construction case, and the parties were coming from the US and Mexico, so they were discussing whether or not the commercial code was applicable to the dispute and the scope of the dispute. So the arbitral tribunal also rendered a partial award in this regard, and they had to present all these statements. You know, there was a hearing to discuss this because, of course, it's a substantive issue that has to be solved before. So when it comes to the pros and cons, I think it's only a matter of money and how much you will save. I mean, it doesn't matter if you have the whole proceedings and then in the end, the arbitral tribunal decides that it doesn't have any jurisdiction. So then all the waste of time and money and all the hearings. I think that would be my conclusion of that.
Absolutely. And I suppose, you know, if the tribunal ultimately decides it doesn't have jurisdiction, then perhaps it might be a matter for a particular court. But I'm wondering, and maybe Mark, you could opine on this, you know, are there points in this process that we've been talking about in which a court intervention perhaps earlier on in a jurisdictional dispute might make sense?
Yeah, so to jump on one of the examples or continue one of the examples, the multi-party situation. I'm thinking if I am one of those multiple parties that doesn't think we should be in arbitration, the idea that you would have a tribunal that you don't think is legitimately appointed to hear your jurisdictional dispute issue a decision is not a very satisfactory one. And so in that case, and presumably if you are true to your jurisdictional objection, you wouldn't participate in the constitution of the tribunal. And there would be, 3 arbitrators and 5 parties. Let's say 1 or 2 parties say they shouldn't be there. How does that work from a standpoint? Either you argue without waiving your rights in front of the arbitrators, or you go to court. And I think in that sense, assuming you have a legitimate opportunity to do that, that is a situation where if you know non-signatory to the arbitration clause or something like that, that is where that makes more sense if it's possible, depending on where you are in the court jurisprudence in that jurisdiction. But that's a situation where I can think that the proceedings in front of an arbitration tribunal just don't fit to the type of objection that you're raising.
Absolutely. And perhaps we can even carry that sort of, you know, example even further and maybe say that, you know, you have a tribunal that, you know, has confronted a jurisdictional question and ultimately finds that it doesn't have jurisdiction. And, you know, there might be some complicated questions in terms of, you know, what the tribunal can actually rule on and ancillary issues like whether it can apportion or award costs for a party. And so, Kate, I'm wondering if you can speak to this topic, you know, sort of how these jurisdictional questions might manifest themselves, you know, in a final award, in a tribunal's ability to award costs.
Yeah, thank you. Great question. And I agree that practically if the tribunal rule that it lacks jurisdiction on the merits, we will typically talk about costs. That's the only, not the only, but the main issue that is there. And the question is whether the tribunal has authority to rule on costs if it decides that it doesn't have jurisdiction on the merits. I would say that the fact that a tribunal doesn't have jurisdiction on the merits does not necessarily mean that it doesn't have authority to rule on costs, but it necessarily means that the tribunal needs to think and analyze and examine whether it has jurisdiction to rule on costs. The first question I would ask is whether the master agreement, the agreement on the merits of the dispute exists. If it exists, but let's say the tribunal does not have jurisdiction because the dispute that is before the tribunal is outside the scope of this arbitration agreement, then perhaps the tribunal has authority to rule on costs based on that arbitration agreement. That is still there, it just doesn't cover the issue, the dispute presented right now. However, if there is no arbitration agreement on the merits at all, it's invalid, it does not exist. In that case, I think it's a trickier question whether the tribunal can rule on costs. And that's where what I call a parachute agreement comes into play. And I'll give you two examples from two different jurisdictions with different outcomes. The first one is a good one from Australia. The case is Commonwealth Development Corporation versus Montague. Mr. Montague filed an ICC arbitration based on the agreement he didn't sign. A tribunal ruled that it doesn't have jurisdiction, but it awarded costs against claimant. And claimant refused to pay costs, arbitration costs. So the Commonwealth Development Corporation filed the enforcement action in Australia, seeking to enforce this cost award. But Mr. Montague refused, challenged enforcement proceedings, saying because the tribunal didn't have jurisdiction over me, it didn't have authority to award costs against me. And in addition to that, the New York Convention requires an arbitration agreement, but the tribunal has just ruled that there is no arbitration agreement. The court enforced the award based on the New York Convention, and it looked and it held that there was a narrow, what I call a parachute arbitration agreement on the issue of jurisdiction and costs. That agreement was present, and that agreement was contained in the terms of reference, where the parties and the tribunal expressly, in that case, expressly agreed that the tribunal will have jurisdiction to rule on its jurisdiction and on the related costs. So this narrow agreement on those two issues, jurisdiction and costs, was sufficient to empower tribunal to rule on costs and to enforce the resulting cost award. That's a first good example. Second case had a less happy ending. It was an investor state arbitration. Sorry, no, we are about commercial arbitration. It was Energorinok versus Ukraine, an investor state arbitration between Ukrainian energy company and the Republic of Moldova. In that case, tribunal also ruled that it didn't have jurisdiction and decided to split costs equally. But because Moldova did not pay its share of arbitration costs, it had to pay that small share under the cost award. It didn't pay, and Energorinok sought enforcement, in that case, in Ukraine. The Ukrainian Supreme Court refused to enforce this cost award based on the New York Convention, saying that you should present me an arbitration agreement. The New York Convention requires, Article 4 requires this arbitration agreement. The tribunal ruled that it doesn't have jurisdiction because there is no arbitration agreement between the parties, so I can't enforce this resulting award. In that,
This is an Altamirano case, Altamirano.
it was a Stockholm Chamber of Commerce. As it seems. Yeah, and in that case, Energorinok, as far as I can tell, did not argue that the parties actually agreed and delegated the issue of A jurisdiction B cause to the tribunal. And the court did not analyze. So the court didn't know the concept of parachute agreement that I came up yesterday night. Yeah, but in that case, actually both parties, both Moldova and Energorenok, asked the tribunal to rule on costs. Of course, they had different opinion how the court, the tribunal should rule, but they asked. So technically that submissions of the parties, both parties could have been framed as an agreement for the tribunal to rule on the issue of costs. But that argument wasn't made and the word was not enforced.
Absolutely. I think those two cases that you mentioned provide sort of really fascinating examples on, how these jurisdictional issues can have a real impact on cases and their outcome and their enforceability later on. And so perhaps before we sort of turn to that stage of the arbitration, sort of the post-final award, enforcement, modification, correction phase, perhaps Grant, we could just turn things over to you from your perspective as arbitrator. Have you been confronting these situations in some of your cases? Any recent examples where you've been called on to issue a final award or interim award, and then there have been interesting developments following that.
Well, I'm going to tell you about, this is very rare for an arbitrator to come to a conference and talk about an award that was set aside. But that's what I'm going to do. So it was an ICDR emergency award, actually, come back to something Mark was talking about. And this is all public, everything I'm talking about is, you can find it in this Monday without a subscription. 2022, we had to do with a global franchise agreement. I'm really summarizing this at a very, very high level. I won't talk about the names of the parties or the council or any of this, but so there was a global franchise agreement, and the allegation was that the franchisees, Singapore, basically just took the franchises. They rebranded them overnight and took control of them and sort of froze out the franchisor. It was a Pittsburgh citus case under Pennsylvania law. And immediately, it's an ICDR arbitration clause, and immediately the franchisor brought an emergency arbitration case. And I agreed to be the emergency arbitrator. This was going to be a big part of the next 3 months of my life, not 15 days, but 3 months. So there were, very quickly we did appeal one, we had parties to make their submissions. Because of the way this all happened, there was a little bit of confusion as to whether the agreements had actually been terminated as part of this process. And in hearing all this, we had hearings, and the arguments sort of changed over the course of the hearings. I had some suggestions throughout the course of the hearings, and the post-hearing submissions were somewhat different than the pre-hearing submissions. And I ruled on the post-hearing submissions. I granted the relief. Franchisor took it to a Singapore court to have it confirmed, which it was, or enforced under the New York Convention. Singapore is one of the very few jurisdictions that I know of that specifically provides that emergency awards are subject to enforcement under the New York Convention. It was then appealed, and on appeal it was set aside. And the grounds for setting it aside was that a new claim had been made in the post-hearing submissions that was not in the pre-hearing submissions, and that the emergency arbitrator had failed to give the licensor sufficient opportunity to respond to the new claim. So it's one of these rare, and at least in my experience, is successful due process challenges. So the licensee, the licensor claim came back to me, said, okay, we want another hearing on our so-called new claim, and give the licensee every opportunity to tell you whatever it wants to tell you. the licensee said, no, you're finished, you're Functus. Your previous ruling is res judicata. Said, I don't think so. I don't think so. I think I'm Functus until there's a tribunal in place. There's no tribunal in place. That's the way that I read the ICDR rules. I was then asked to recuse myself. I was then challenged. Recuse myself. I was unsuccessfully challenged. I had a submission schedule. They refused to submit on the merits. They only submitted on these jurisdictional challenges, which I rejected. So then I issued another, what's called a emergency award, I think they called it. And that was enforced in the initial court. It was enforced, it was affirmed on appeal. And the final award, which came out last year, the arbitrators basically wound up maybe agreeing with both the initial award and the amended award, and said that if the licensee had abided by it, complied with the initial award, emergency award, they wouldn't have suffered the damages. The licensor wouldn't have suffered the damages which the tribunal ultimately awarded the licensor. So you do have to be very careful. You know, I think that particularly in the United States, where we have concepts of notice pleading and our litigation, we're not as attentive as civil law jurisdictions are to making sure that claims, the relief matches the original claims, and if things change during the hearings, be very clear about how they've changed, and making sure that the respondent, counterclaim respondent, has had an opportunity to respond to them. And that's part of why the ICC has the terms of reference. I think a lot of people say the terms of reference are sort of antiquated. We have an example of what's important, and I think it can help in defining the claims. If you're going to amend the claims, then you have to revisit an initial pleading of some kind. So I'm not arguing for terms of reference in an ICDR conference, to be sure, but it does have that function. So anyway, there's a story of an arbitrator talking about an award themselves.
Thank you. That is such an interesting example, and I think provides sort of a perfect transition to sort of the last topic that we wanted to address very briefly, because I know we're close on time and don't want to stand between everyone and, you know, cocktails and networking. But I think, Grant, you were talking about sort of when does a tribunal go functus, or, you know, loses its sort of, you know, jurisdiction, is divested of that jurisdiction that it at one time possessed. And I think, Grant, you provided a very, you know, interesting and colorful example of when that may or may not happen. But perhaps, Frida, you can, you know, provide a little bit more context of the circumstances in which tribunals might lose their jurisdiction or retain their jurisdiction in a case.
Yeah, of course, we have the option of the party agreement now, whether or not the arbitral tribunal will retain jurisdiction. And I will also refer to rules. We also have terms of reference in Article 24. So there is this possibility that the parties agree that the arbitral tribunal will retain jurisdiction over some issues. And actually, I will just jump on the second issue, that how to address some corrections or modifications of the awards. You know that it also comes only to typos or some calculations or miscalculations of the award. But now, under our rules, there is this possibility to ask for a clarification from the arbitral tribunal under Article 36, and then the other party has 15 days to send a reply or any comments, and then the arbitral tribunal has to issue an award on a decision on whether or not this clarification has to be done. And what I have seen is that more and more the parties are trying to use these clarification proceedings as an appellate body. You know, they try to say, okay, there is something wrong in the calculations, and then they argue that maybe the arbitral tribunal didn't went through all the evidence. So they try to make some arguments regarding the evidence and all the calculations that they provided, or maybe additional information. So they are trying to bring this additional information, and of course, a claimant and respondent on the other side say, of course, this is not a clarification, and this not the purpose of these proceedings. So I think that is more and more common, and also in Mexico, we have some proceedings that are called amparo proceedings, that sometimes the parties argue that at this stage of the in the courts, they have this additional option, so they argue in front of the judge that the judge should review all the decision and should clarify or make some mistakes and fix it.
Absolutely. And perhaps maybe just as a final question, I will turn things over to perhaps our in-house and our outside counsel perspective, just to sort of, perhaps piggyback on the topics that Frida was discussing with respect to clarifications or modifications of awards. Do you find that there are certain risks when parties seek to clarify or modify awards? What is your sort of experience with those?
Yeah, so I think most institutional rules, at least on the international side, really tightly constrain what that procedure is for, both in terms of duration, you have 15 days, 30 days, whatever it is, and in terms of issues that you can address. So it's not to be like under disguise reconsideration or appeal. And I think most tribunals following that stick to that. So it's more of a, I think, nuisance if you're won the arbitration. If you haven't and you want appeal rights, then okay, that's not helpful. I guess you have, set aside or whatever, but potentially appeal within the arbitration depending on the rules. But I think mostly the intent of those provisions is respected. We were talking a little bit earlier here about however, some clarifications, especially in cases involving a lot of money, where, there was one example recently where it moved, the clarification was admitted, accepted, but it moved the needle by tens of millions of dollars. And so that type of clarification, I think, is a much larger risk when you start seeing, DCF models in investment cases, for example, where, let's be honest, the tribunals are not economists, and so that kind of math can, depending if you tweak this variable here or there, move the needle. But in commercial cases that don't involve that type of economic modeling, the very sophisticated economic modeling, I think the risks are much lower, and you generally do get the intent of those provisions being limited to clarifications, supplementation, whatever it is, correction.
There's a little bit of interesting language in the ICDR rules. Like everyone's saying, it's a very narrow scope for this type of request for modification or correction. But the Article 36 of the ICDR rules do say that within 30 days after issuance of the final award, the tribunal may interpret or correct only any clerical, typographical, or computational error. Like Frida was saying, computational in people's minds often becomes, you calculated the damages wrong and that's why I lost. But yeah, it's a very narrow window, and when those do come in, tribunals tend to really only, it's a typo sort of correction. And I like too that the last subsection of the ICDR rule addresses costs for this type of post-award application. So there's a little guidance there. It just says the parties shall be responsible for all costs associated with the request for interpretation, correction, or an additional award, and the tribunal may allocate such costs. So that I've seen that become kind of a whole nother issue. So it's nice to flag that and have the tribunal also make a decision on that, if any, when they're disposing of that request for correction.
Can I quickly jump in? I think there's one use for these types of mechanisms that probably is not permitted by the rules currently, but I have seen a lot of sophisticated tribunals effectively not issue a reasoned decision. They will summarize 80% of the award will be, here's the procedural history, copy paste from the pleadings, and then it'll be a declaration. We decide, here's the pleading on one side, here's the pleading on the other side. We declare the more convincing one is X. And there's no reasoning. It's effectively an unreasoned award, even though it's 80 pages long or 100 pages long. And I have used that mechanism to try to get the tribunal to at least put the reasoning on paper. Of course, they can't change the decision, but then that becomes something you take into account. Well, would the decision be different Or should you try to use that in a set aside?
The ICDR rule delineates any interpretation made or correction made by the tribunal shall contain reasoning and shall form part of the award. So that's some extra, finality language in there too.
Absolutely. Well, unless there's no further comments or intervention from our panelists, we'll just thank all of you for attending and each of our panelists for speaking here today. And perhaps we could also open it up to a few questions either from you, the members of the audience, or people that we have on our Zoom. Yes.
I'll stand up so you can hear me better. I have a couple of observations. I want to go back to the question about whether when you draft a clause, whether you should specify whether the tribunal has jurisdiction for interim measures. And that's actually an interesting question. A lot of people don't realize that the rules themselves, if you refer to the AAA rules, allow you to go to court, get interim measures. So it's kind of I had it up, Rule 38 of the AAA rules. I just lost it, but it says that a request for a judicial intervention shall not be considered inconsistent with the agreement to arbitrate. So it's kind of interesting when you're clause drafting, think about, do you want the tribunal to give your interim measures or do you want a court to? You could go either way. My view is that you probably shouldn't say anything about it because you want to maintain maximum flexibility. If you want to go to the court to, give a motion or seize collateral. So, but there are some people who say, well, I only want tribunal to do it, but the ICC rules are similar. I don't know if the ICDR rules are like that. That's kind of an interesting consideration when you're in the contract formation stage.
Yeah, and I think the intent is to, at least when I draft these types of clauses, because I do sometimes still put in a non-exclusive submission to jurisdiction, because when you see it in the institutional rules, like the ones you're referring to, it is usually saying intervention is not impermissible, it's not inconsistent with the consent to arbitrate, right? Fine, but it doesn't positively submit to any court jurisdiction. And sometimes if emergency or expedited proceedings are not enough, you may want a submission to a neutral court jurisdiction. If they allow that, I mean, sometimes there's, you can't just agree in a contract to submit to that court jurisdiction. Sometimes you can. But sometimes I put that in there to avoid the issue of finding a jurisdiction if we need truly, really expedited relief and for whatever reason don't want expedited or emergency.
On the other hand, if you think you're going to be the enforcing party, you might want to maintain the maximum amount of flexibility that way.
Yeah.
And so if you allow me the second observation, I'd like to make kind of similar to Grant's story, is that these are not really, just emphasizing these are not really theoretical issues. I had a case, a AAA case a few years ago. This is all in use for me too, where it was one of these form sales agreements where somebody was selling equipment to someone, and then at the end of the form, it had the owners of the business guaranteeing. And then there were standard terms and conditions at the end, which had a AAA agreement to arbitrate. So, seeing what's coming, right? The buyer didn't pay for the stuff. And then the seller sued the guarantors. Sued the guarantors, put a AAA arbitration against the guarantors. Then argued that the terms and conditions didn't apply to them, so that the tribunal has no jurisdiction. And the details, but I thought that actually the terms and conditions covered it. But the counsel to the guarantors objected to the jurisdiction. I said, well, you refer to the AAA rules, so I'm deciding the jurisdiction. And they, so I issued the award against the guarantors. And the counsel for the guarantors said I was violating their constitutional rights. And I was reminded that 8 of the Bill of Rights says that in any case of common law over $20, you have the right to a trial by jury. And I looked, this happened to me in New Jersey, so I looked at federal cases and the Third Circuit, and you'd be surprised they're all over the law. There are a lot of cases, even in New York, that go both ways. They say, no, only the court can decide. And some say only the tribunal can decide. So the point I'm trying to make is the law is not at all that clear on this. So anyhow, punchline, can't give you punchline because it's actually still pending. The district court in Jersey.
Maybe that's the
We're gonna see if I'm
punchline.
right or not, but, I'll let you know when you hear.
Thank you. Any other questions or comments? Great, well then please join me in thanking our panelists and thanks to all of you for being here today.